only. If the tentative is in favor of appellant, it is perfectly acceptable to decide to reserve all your time for rebuttal, and I will ask you if you want to do so. If you are appearing by telephone, we want to assure you that you are not at a disadvantage. After 3 years of COVID, we are accustomed to telephonic as well as remote appearances. We will take a 5-minute break after number 1 on the calendar. Before we begin the morning calendar, I want to list for the record the cases where oral argument has been waived, the appeal has been settled, or the oral argument has been continued to a later date. Those cases are People versus Balbuena is submitted. DCFS versus Judith R. is submitted. People versus Seha is submitted. DCFS versus GF is submitted. DCFS versus LD and BS is submitted. DCFS versus Lance V, is submitted. People versus Rivers is submitted. Argueta versus Worldwide Flight Services is continued to September. Ross versus Seyfarth Shaw LLP is continued, and People versus Thomas is continued. Arnold versus Witzer has been taken off calendar due to a bankruptcy stay. With that, I'm going to turn it over to Justice Grimes to call the first case on the calendar.
Thank you, Presiding Justice Stratton. The first matter on calendar is Robson versus MJJ Productions and Chandler et al. The panel is Grimes, Wiley, and Viramontes. We received a last-minute media request, which is granted on the following condition that we had no intention of delaying proceedings. So if the last-minute media request may be initiated without causing delay or interference, then the request is granted. We've also granted previous requests to record these proceedings. The tentative in this case is to reverse the judgments against plaintiffs and to affirm the rulings on the discovery motions. Ms. Boyer, do you wish to reserve any time for rebuttal?
Good morning, Your Honors. Yes, we agree with the court's tentative ruling, so we would like to therefore reserve all our time for rebuttal.
Very good. I was hoping you'd say that. Okay. And Mr. Kunkel, we can wait. I doubt we'll need to hear from you either, but we'll see. Mr. Steinsapir?
Correct. Before I begin, is it okay if I reserve some time for rebuttal?
No, it's not. You're the respondent.
Okay, well, thank you. Shall I begin?
Yes, please.
Okay, good morning. May it please the court, Jonathan Steinsapir of Kinsella Weitzman for the defendants and respondents in these consolidated appeals. And it's on the consolidated point that I want to start. The court consolidated for purposes of decision, and that's the court's prerogative, of course. That said, the Robson and Safechuck cases are two very different cases involving different people and different time periods. Legal issues overlap to a large degree, but the factual records and the procedural posture are very different. And that's my first issue with the tentative opinion. The Safechuck case is on the demur stage. No meaningful discovery was taken in that case. Nothing outside the four corners of Safechuck's latest complaint is before the court except for a few judicially noticeable facts. The Robson case is quite different. It was on summary judgment, not demur. A lot of discovery was taken over many years. 30 plus depositions were taken across the country. Over 100,000 pages of documents were produced by both parties, by third parties. As a result, there's a ton of evidence before the court in the Robson matter, yet the legal analysis section of the tentative does not meaningfully distinguish between the allegations in the Safechuck case and the actual evidence or lack thereof in the Robson matter. So I will get into more detail on this below, but despite what the allegations of the Safechuck complaint were, there is no evidence in the Robson summary judgment record that, quote, the corporation's employees assured Robson's parents that they would be well taken care of. No evidence that Robson's parents were instructed by corporate employees to sleep only in guest quarters. No evidence that he was allegedly molested at a recording studio controlled and staffed by the corporations. And there's more examples of this, as I will discuss, but the bottom line is that, respectfully, I think the tentative could be much more careful with the extensive record here, and also make clear that every assertion in there by witnesses like Blanca Francia, Charlie Michaels, and others are allegations. They're not proved, and if this tentative holds, we believe they will not be proven because they're not true. With that, I do want to turn to duty, and I'm going to get into the special relationship, but first I want to talk about the specific duties that are proffered here. Now, for two claims, that's easy. The claim for negligent hiring and the claim for negligent supervision and retention. On the first, negligent hiring, the evidence is undisputed, at least in the Robson case, where they had an opportunity to take depositions of anyone they wanted. The purpose of MJJ Productions when it was created in 1979 by a 21-year-old Michael Jackson was to loan out his personal services as a recording artist. That's volume 6 of the Robson redacted appendix at 33-37. It's also undisputed, again, at least in the Robson case, that the purpose of MJJ Ventures when it was founded in 1991 was to loan out Michael's personal services as a partner with Sony and a media company and record label. Volume 6, Robson redacted appendix 33-39. Now, in what world was Michael Jackson, 21-year-old, sole shareholder and sole director of these corporations when they were created, under a legal duty not to hire himself? And are you really saying that anyone who others might suspect is prone to criminal activities has a duty not to hire himself? Is someone...
No, I don't think we said that.
That is exactly what was said, Your Honor, with all due respect. The discussion of negligent hiring, well, there's almost no analysis of it, with all due respect. It's a half page of analysis on page 28. And Judge Beckloff and Judge Young, on different occasions, grappled with this and said exactly what I'm saying. This tentative just does not respond to that. And again, what if you're saying that any person who, might suspect that they're prone to criminal activities has a duty not to hire himself?
No, we did not say that, and we do not intend to say that, and I don't even follow the logic.
I don't follow the logic either, Justice Grimes, but if you look at page 28 of the tentative, with all due respect...
I've read it, and I did not say that.
Well, then I don't understand how a negligent hiring action can possibly be sustained. You're saying that Michael Jackson had a duty not to hire himself.
No, I'm not. Would you like to move on?
Well, I will absolutely move on, but I will say that Judge Beckloff and Judge Young both grappled with this issue, analyzed it, and we got a half a page of analysis in response. Almost precisely the same thing can be said about negligent supervision and negligent retention. Your Honor, you gave us a half a page of analysis on this, and you're saying that Michael Jackson was under a duty to fire himself? Again, I don't understand the logic there. And maybe you need to clarify, but a negligent hiring claim is that someone was negligently hired. They should not have been hired. Okay, Michael Jackson was hired by Michael Jackson in 1979 and in 1991. He was the sole director, sole shareholder of this company. So at least on those claims, I don't see in what world how they get past demur, let alone summary judgment, as two learned trial judges found. But turning to the more general negligence claims and the negligence-based duties, and this relates to the letter with supplemental authority we sent to the court a few weeks back on July 13th. Citing this division's decision in Romero versus the Rams from April of this year. The tentative in this case says on the second page that these corporations had an affirmative duty to protect children. Fair enough, I will talk about special relationship, but I want to talk about the duties first. In Romero, there was no doubt that there was a duty to protect, generally. But as the court pointed out, quoting our Supreme Court, in a case that we cited in our briefs, but that's not cited in the tentative, the decision's Castaneda versus Ulcer. It says the scope of a duty to protect is a question of law. And this division noted that the analysis of duty requires the court in each case, whether trial or appellate, to identify the specific action or actions the plaintiff claims the defendant had a duty to undertake. That frames the issue for the court's analysis. That's in Romero at page 569. It's quoting Castaneda versus Ulcer, again, a case we've cited repeatedly, 41 Cal 4th, 1241. And Romero, or in Castaneda, after they defined the specific duty to protect, in that case it was not to rent to gang members, do they then go through the Rowland analysis? And in Romero, after the court defines the specific duties, which is to provide more security, to provide radios to security guards, then they go on to do the specific analysis of causation. And by the way, this is what happens in cases involving alleged child molestation as well. Cases we cited that both Judge Young and Judge Becklock cited that the tentative does not address. So, for example, Doe versus Youth Soccer, 8 Calap 5th, 1118, cited repeatedly in our briefs. The court agrees in youth soccer that there was a special relationship and a duty to protect underage players for soccer league. However, it then conducts separate Rowland analyses on the two specifically proffered duties. Or in the words of Castaneda or this division in Romero, it analyzed the specific acts that the league had a duty to undertake. One proffered duty was performing background checks of coaches, and the court agrees Rowland compels that duty. But in the other proffered duty, a duty to train or warn, the court finds that Rowland does not compel such a duty, just as the trial judges found here, based on that very case. Yet the court does not address it. Now, this court seems to assert that what the duties are, the closest it comes, is at page 25, when it says that employees or directors, and I take issue with directors because there was only one director, Michael Jackson, until June 1994, but we'll set that aside. But employees or directors should have, 1, issued warnings, 2, gone to the police, or 3, confronted Michael Jackson. Okay, and I want to talk about these duties. Saying that employees here had a duty to warn, go to the police, seemingly turns any person who comes into contact with a child and reasonably suspects abuse into a mandatory reporter. The state has a mandatory reporting statute, as does every single other state, I believe. Statutes are balances of many interests. When you create a scheme that requires reporting potential child abuse based on a reasonable suspicion standard, there's inevitably going to be reports made against innocent people. Of course,